But when you're 55 with 5 prior felonies, 31 prior misdemeanors, I think you kind of understand what you have to do.
Right, we point out that well enough he shouldn't have firearms. He didn't have one firearm, he had 6, 4 handguns.
Let's pause right here. This is already stacking up fast. 5 prior felonies, 31 misdemeanors, and now multiple firearms? Legally, this is a nightmare for the defense. In most states, once you're a convicted felon, possessing even one firearm is a serious offense. This man had 6. At that point, the court isn't asking, did he know better? They're asking, why didn't he stop? So here's the question for you. Does past history make the sentence inevitable, or should every case still get a clean slate?
It's a set forth that he be sentenced on the felon in possession by a prohibited person to the 24 months mandatory, the felony firearm mandatory with 7 days credit for that one. And then for the other count, the recommended 24 months, and that is going to run consecutive to that with no credit.
The second 2 files are new sentencings. The defendant is present, represented by attorney Dallas L. Rooney. People are represented by prosecuting attorney Timothy J. Murkowski. For purposes of the 21 file, the defendant, and actually in all files, that is, on January 26, 2026, Mr. Gallagher pled to probation violation. In 7377, he pled to possession of a weapon by a prohibited person ×2, as well as felony firearms and possession of a controlled substance. In the final file, 7378, the defendant pled to delivery of a controlled substance. Ms. Karen Everlin has prepared the pre-sentence report for the new files. Ms. Mandy Alexander prepared the...
His prescription had been reduced by his doctor who was having pain. That his son, who was having some mental health problems, was going to be living with his mother. They were worried about that son, perhaps for a suicide. Looking back, he should have made other arrangements when his guns out and taken him to his house, but he was doing what he thought was the lesser of 2 evils of dust. Then as far as controlled substance deliveries, according to my client, that the CI was a friend of his who he had known for some time in the construction world, and his friend had told Scott that his prescription had been reduced by his doctor and he was having pain. Even Scott, carpet laying and flooring is really bad on your body.
And on your knees and your back.
So he thought he's helping this friend by giving him or selling to him his deceased relatives' leftover supply. Again, it's a bad decision. He's not a doctor, not a pharmacist, but at the time he thought he was helping his friend. It turned out to be a confidential informant. As far as the recommendation,
this is where the defense tries to humanize everything. And honestly, it's compelling. Pain, family struggles, trying to help a friend. But here's the legal problem. Intent doesn't erase illegality. Selling controlled substances, even to help someone, is still a crime. And that friend turns out to be a confidential informant. That twist alone has sunk countless cases. So let me ask you, should motive matter more than the law here, or is this exactly why these laws exist in the first place?
does acknowledge that he made some mistakes that are crimes and that he has to be held accountable for his actions. If you recall, he did plead guilty to virtually everything that was charged against him.
Also, is there any objection to one pre-sentence report covering the two newest files? Does your client wish to address the court? Please, go ahead, sir.
And father, and our husband, prior
All did do the right things. Trying to protect my family. Like, wounds and stuff, I wasn't good people. All this stuff's done with the probation violation. Yeah. Violence. 120. Scared. What's she saying? So I'm trying to play the sheet. Looks like me.
Anything else?
Really just all that.
This was Nighthawk, was it not?
Yes, it was.
Can't stress enough. It's a new day in Huron County. It has been for a couple of years now with the Nighthawk program. This is a Department of Corrections program. When individuals are placed on probation, it's been, at least from my experience in the past, across the state, frankly, I have practiced across the state that people placed on probation are placed on probation. They report to the probation agent, and they're not looked upon in a surprise situation. In other words, when you schedule your meeting with the probation agent, meet with the agent, you report to the agent, that's all. And you're done. The Nighthawk program is a completely different program. Department of Corrections individuals will come to your house when you least expect it. And when they show up, they have the right to search the home, premises, computer, everything, vehicles, to make sure individuals are compliant. And we've had a number of cases come before this court, including this one, where an individual is merely on probation for operating while intoxicated or defense, and they're in possession of firearms or ammunition. And the court every time will tell the individual who's on probation to be placed on probation, you are not to possess a firearm. Period. On top of that, individuals who have prior felonies know that as well. Once you're a felon, unless your rights have been restored, you do not get the right to possess a firearm. And that's what happened here. Not one, but Mr. Rakowski, 6. Yes, sir. 6 firearms. And the explanation is, well, I'm concerned about my son. And the court appreciates that. I'm not discounting that, Mr. Goblin, at all. But they can't be in your possession, in your home. There are other avenues. Easy for the court to say no. I mean, we're armchair quarterbacking this, Monday morning quarterbacking this, essentially. But there's a proper way to do it. Sadly, you didn't do that. On top of that, you fell upon maybe the weakness of another individual in controlled buys, and you delivered a controlled substance. I'm not considering the other alleged incident. I'm only considering the one you pled to. That's all we're considering. But when you're 55 with 5 prior felonies, 31 prior misdemeanors, I think you kind of understand what you have to do. And sadly, you didn't. And you have to be held accountable for that. So it will be the sentence of this court. And this is under statutes. This is mandatory. This is file 7377. I'll begin with count 4. The defendant is admitted to the Michigan Corrections Commission and placed in their custody for a period of 2 years, flat. Credit for 7 days previously served. $68 in state costs will be ordered. In count 1, count 2, and count 3, it will be the sentence of the court that the defendant be committed to the Michigan Corrections Commission, placed in the commission's custody.
And here's where it all comes crashing down: consecutive sentencing. That means these punishments don't overlap, they stack. Legally, this is huge. What might sound like a few years can quickly turn into decades. The judge is also bound by mandatory minimum laws on certain counts, meaning discretion is limited. This isn't just punishment, it's a structured legal formula playing out in real time. So, final question: Do mandatory minimums ensure fairness, or do they tie the hands of judges who might otherwise show leniency?
Again, credit for 0 days served, $68 in state costs in that file, in that count as well. Counts 1, 2, and 3 will be served consecutively to count 4. And that's by law. In 7378, it will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission, placed in their custody for a period of not less than 24 months to a maximum of 40 years, credit for 7 days previously served. 7378 shall run consecutive to count 4 in 7377, but concurrent to 7377 count 1, 2, 3. It will be the sentence of this court that the defendant be placed in custody of Michigan Department of Corrections for a period of not less than 18 months to 7.5 years, credit for 218 days. He's unsuccessfully discharged from probation. All monetary obligations remain collectible. This sentence shall be served concurrently with all the other files except for count 4, which is the felony firearms count. It must be served consecutively. Again, May 18, 2026 would be the due date. Anything that was missed, Ms. Everett? All right. It's my duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, court will assign counsel.